We'll walk through it, a couple witnesses on H222. Over to you, Michelle. Thank you for being here.
Sure. So good afternoon, Michelle Childs, Office of Legislative Counsel, and we're taking up H222 as introduced. And I'll just set the foundation a little bit for the discussion of the bill. Just a little reminder that when we are talking about domestic violence, there's two tracks. There's the criminal track, and then there's the civil orders of protection. And those two tracks can both be happening, or one or the other, but they don't have to be tied together. So there could be a criminal prosecution for a domestic assault, but the plaintiff has not sought a civil order of protection in the particular case, or vice versa, or there could be both going at the same time. This bill is just talking about the civil orders of protection. And also as a reminder is that when a plaintiff files for an order of protection, they have the ability to file for an emergency ex parte, meaning that the defendant is not present at the hearing. They can file for the emergency order. Those emergency orders are for a set limited time of 10 days. And then there's a hearing about whether or not to issue a final order. This bill is just addressing final orders. So it's not amending the law with regard to the emergency orders. Okay. So if you look at page 1 of the bill, so section 1, we're in title 15, your domestic relations title. So section 1103 on request for relief. So it just sets forth, and there's no changes to the procedure for how someone goes about obtaining an order. I'll just draw your attention to page 2 in the existing law. Subsection C is around what the court has to find to be able to issue the order of protection. They have to find that the court has to find that the defendant has abused the plaintiff according to the abuse definition that is in the chapter, and that there is a danger of future abuse. Okay. And so those two things have to be found by the court. It's we're talking in the civil context. So we're talking about a preponderance of the evidence standard. There's a few just little technicals where we're taking out some gendered language. And you move over to, I guess maybe the intro for what I'm going to talk to you about is on C2. So the court makes those findings, is going to issue an order of protection. So subdivision 2, which starts on page 2 on line 16, the court may order the following. And so there's a long list of things that are within the court's purview to order as part of the final protection order. And you'll see a number of those around defendant refrain from abusing the plaintiff or the plaintiff's children. Page 3, existing law, subdivision 2B, in order that the defendant immediately vacate the household. C is temporary award of parental rights and responsibilities. Could be an order for parent-child contact. If there's any support obligation for any minor children of the plaintiff. Turning to page 4. You'll see there's a new one on lines 11 and 12. And this would be permitting the court to order the defendant to complete a domestic violence accountability program that's approved by the Council on Domestic Violence. So I'll just note here, and I've talked to the sponsor and the chair just about a couple of questions I had. I think that this, if you decide to move forward on this, there's a couple things that as you're speaking with the witnesses who have the expertise on these types of accountability programs, I think it would be helpful to get a little more information about, well, what would be considered completion of the program? Do you get a, sorry?
Those accountability programs now?
Yes.
We do, okay.
Yeah.
We have a witness coming in tomorrow.
And I assume you have someone from Council on Domestic Violence who's one of your witnesses, and I'm sure some of the network and other folks can talk to you about.
They're not required.
They're not required, but this would be allowing the court as part of a final protection order to make it a requirement that defendant, because remember that one of the things that the court has to find in order to issue the protection order is that there's a danger of the defendant abusing the plaintiff in the future. So the court would have, so this wouldn't be automatic. It would have, but it would be on a case-by-case basis that the court would have the authority to order the defendant to complete one of these programs. So one of the questions I had is what constitutes completion? And then also in terms of, attendance and completion, does somebody just need to show up? Do they need to participate? Those types of things. So getting a little more information about about those programs. And then I think maybe once we get that and you can direct me, maybe we can refine the language a little bit.
So those are some of the questions on my mind, even not knowing if there was programs already.
There's a number, I think.
It looks like there's gonna be a lot of work to do just with those 2 lines, as far as getting everything lined up to.
My understanding is that there's a number of programs out there that offer, there's a number of organizations throughout the state that offer these programs. And I think the witnesses can probably talk to you a lot about how they operate now and what they involve.
Ian. Oh, go ahead.
Well, I was just going to say, it's important that we're really clear here about what is being ordered, what the court is ordering, because remember that if someone violates a civil order of protection, it is a crime. So under 13 VSA 1030, it is a misdemeanor to violate an order of protection. So just now, like under the existing, if a defendant was ordered to stay away from the plaintiff, don't, come within 100 yards of the residence, things like that. If they were doing that, that person could be charged criminally. And so we want to be very specific that we're being very clear about the prohibited conduct and what the court's going to have in there so that somebody understands what they're allowed to do and not do.
Yeah, go ahead.
So I think probably this question's mostly for our witnesses, but I wanted to bring it to you to hear your thoughts. My concern is kind of going back to the beginning of your presentation, like the criminal and the civil. And that, what I see a lot of times in these instances is that you have an RFA that accompanies a criminal charge.
Mm-hmm.
And that the RFA, there's a stipulation for no findings, so that the defendant does not incriminate themselves in a civil proceeding. What I would be really concerned about with this is that you'd have that instance where you'd have a stipulation, no findings, and then the court would order this domestic programming, and then to comply, they would have to essentially potentially incriminate themselves in the civil setting. Is that a reason, like, am I reading this right, that concern is there, or?
I think that's very valid. Again, I don't know about the extent with the programs, about in what is, what's considered completion or successful completion of the program. Do you have to admit to certain conduct? And then therefore, could that be used against you? I know that this is an issue that has come up for years around types of things around programming in other contexts. And so, but I will just say, I think as we learn more, we can craft whatever it is so that if there is something around accountability in that program, that it can't, if you want to make sure that participation in that program then can't be used in a parallel criminal trial, then we can account for that in the language.
Thank you.
Yeah, that would seem to make sense if these are not confidential programs. So, but we'll find out from some of the other witnesses on that one, definitely. But good question. Any other questions for Michelle? So far, so good.
All right,
I'm sure there will be further questions though.
I'm gonna stick around for a little bit.
All right, we'll hear from the network next.
Good afternoon.
Afternoon.
Wow, that was great, guys. I'm Charlie Glosserman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. Thank you for the opportunity to speak with the committee today about H222. I'm also joined by my colleague, Heather Holter, who is the co-director of the Vermont Council on Domestic Violence and is available for questions on the operations of domestic violence accountability programs. On behalf of the Vermont Network and our 15 member organizations, we're pleased to testify in support of H222. I have a little bit of background that I want to provide on domestic violence protection orders and domestic violence accountability programs as context for the conversation. Domestic violence protection orders, also called relief from abuse orders or RFAs, are a critical legal tool for survivors of domestic violence. These are civil court orders requested directly by a victim. And as Michelle covered, they can offer important protective measures to prevent future harm, including requiring a perpetrator of violence to maintain physical distance from a survivor. And in applying for an order, survivors can request a variety of forms of relief to keep themselves and their loved ones safe. And that statute explicitly lists the forms of relief that a court may order for a period the RFA is in effect. So H222 proposes adding completion of a domestic violence accountability program to forms of available relief in the statute, which is a recommendation of the 2024 Domestic Violence Fatality Review Commission report. So a little bit about domestic violence accountability programs, also called DVAPs. They are community-based treatment programs that exist now. They are designed to address the needs of people who use violence in intimate partner relationships. DVAPs acknowledge that abusive partners are in most cases capable of change and seek to modify behaviors and develop skills to prevent future abuse. Vermont has 12 community-based DVAPs that offer in-depth group programming. Most participants are court ordered to attend as a condition of a criminal court sentence. Last year, 25% of participants were referred to programming as a condition of their probation by the Department of Corrections. An additional 11% were referred by DCF as a component of a case plan, and 3% of participants were self-referred. DVAPs are required by statute to be certified by the Vermont Council on Domestic Violence. Every 2 years, DVAPs undergo a rigorous certification process, which evaluates alignments with state-based standards. It includes a document and policy review and an evaluation by an interdisciplinary community review team, including law enforcement, domestic violence service providers, DOC, DCF, and the state's attorneys. While DVAPs are not the sole vehicle for holding abusive partners accountable or changing behaviors, they are a critical component of our response to domestic violence and can improve outcomes for both survivors and people who use violence. Investing in DVAP programming was one of the primary recommendations of the Justice Reinvestment Initiative in Vermont in 2020. The JRI recommendations highlighted the important role that domestic violence treatment has in promoting desistance. So a little bit about H222. A large number of survivors do pursue civil protection orders and no parallel criminal process, though as Michelle noted, there are circumstances that are individual. There are many reasons why survivors may not report to law enforcement, like the emotional or financially taxing nature of a criminal case. So currently, there is a significant gap in the referral pathway to DVAPs in civil cases. It is unlikely that a survivor's current or former partner will be referred to a DVAP without a criminal process, even if it is what the survivor wants. In 2023, the courts granted approximately 1,000 final relief from abuse orders, but only 400 people enrolled in DVAP each year. So with these new programs coming online in 2025, for DVAPs, they will have the capacity to provide this valuable treatment to more people. Many survivors report that DVAP programming will change behavior for their partners and would be extremely helpful as part of a civil protection order. Survivors may want to reduce risk of violence for their shared children or a future partner or themselves if they want to maintain a relationship. Earlier access to DVAP programming can help reduce risk of violence before abusive behavior escalates. H22 would expand options for survivors and the court and support people who cause harm in accessing services to change their behavior and lead a better and safer life for themselves and others. So we appreciate the opportunity to testify today. Heather and I would both be happy to answer any questions.
Absolutely up to you. I didn't prepare.
Yeah, no, if you can join, if
Just-
there's, maybe one of the things, get a separate chair.
I-
Or,
Just slide in right here.
yeah, that's good. So I have a quick question.
Mhm.
400 to 500 people who enroll in DVAP each year.
Yes.
That's not pursuant to the 1,000 final RFAs, I assume.
Yeah, so that is entirely separate. So I think the message behind that statistic is that there are a lot more people that are moving through the civil RFA process than there are who have a referral pathway to domestic violence accountability programming.
Okay,
And so with H222, it would create that referral pathway. 85% of people who are in the position to access DVAP, they are being referred by the Department of Corrections as a condition of, a criminal sentence. So
other questions, and I'm sure we have the other questions that we want to ask that Michelle had mentioned, but are there other questions? Tom and then Ian.
What would the costs of the program be?
to the participant.
Yeah.
So there is no cost to the participant. That was a change that was made. And I think Heather, you can speak a bit more about that.
I can. So part of the outcome of the justice reinvestment work, so justice reinvestment part 2 was recommendations about accessibility of programming. And that can talk more about all different kinds of accessibility. But one of the first things that was done was to actually provide state funding for DV accountability programs, because there had been years ago, but there was not, when this change was made, which is 3 years ago. So establishing funding for the programs and then eliminating participant fees completely. So it used to cost someone around $1,200 to participate in a DV accountability program. And for the last 3 years, that has not been the case. So much of the work of justice reinvestment is to remove barriers to people participating in the program.
Is that ongoing money though? Is that ongoing funding?
It is.
Baked in?
Yes.
Okay, all right. It's in the governor's budget recommendation, presumably. Is that-
Yeah, I'm sorry, I'm looking at Sarah. Who's
By yourself for the record?
Yeah, Sarah Robinson from the Vermont Network. It is base funds from the Department of Corrections.
Okay, great, thanks. And do we need to have the Department of Corrections in for this expansion or?
So
Are they on board? Are they on board with this, or are they part of the Fatality Review Commission? I can't remember if they are. There's so many people.
So I'm seeing Sarah nod that yes, they are a part of the Domestic Violence Fatality Review Commission. This is also a change that is, specific to the civil RFA process.
I guess is the cost it's still not going to be a cost because DOC is going to pick up whatever additional costs there are from additional people potentially being sent to this?
Sarah,
Well, I was just gonna say, we're not asking for any increased funds from the Department of Corrections. So the,
Okay.
that $850,000 base funding is what we anticipate needing in the coming years.
Okay. Is there an anticipation of how many more people might be sent to this or?
can I add to that?
Yeah.
And try to answer that. I mean, I don't think we can know yet exactly how many people, but the other reason that we kind of discussed, looked up that, it's a little over 1,000 final relief from abuse orders that are issued, is that I was trying to imagine how many more people this could mean. So we know that survivors won't ask for this relief in every case, probably far from it. So even if, let's say, a third of the final relief from abuse orders that are issued for 1 year were to include a provision, that is an increase that we can handle with the programs that we have right now. So we have 12 programs across the state, and we're actually, we added a 13th youth program this year. We are adding another program in Lamoille that's in pilot phase right now. So that's, sort of napkin math, but I think it's pretty, a pretty educated, yes. That's my thinking.
I don't know who this is for. So we have the accountability programs already. and people are going to, where are the people coming from? Is it court ordered?
Yes. So 85% of participants are referred as a condition of their probation by the Department of Corrections. And then an additional 11% are referred by the Department of Children and Families as part of their case plan. And then a small number, 3%, self-refer into the programming. So right now, there is not a referral pathway for survivors and people who cause harm that are only engaging in the civil court process and not the criminal court process.
And how many, on average per year, how many people are going through the programs? I think you.
We're going through between 400 and 500 people enroll each year.
And again, you may have already said this. What do you predict?
For an increase, if the bill were to pass. Heather, you want to?
Yeah. I mean, again, this is just, right, a guess based on my experience working with people who apply, survivors who apply for relief from abuse order. So in order, as the bill, as I understand the bill right now, what would need to happen is a plaintiff, a survivor would have to request the relief. And I think about now, we made an addition, right, that survivors have to request that firearms be removed, right? So not every survivor will make that request. Not every survivor, not every plaintiff is going to request that their partner, the defendant in this case, be ordered to complete a domestic violence accountability program. So if you figure 1,000 RFAs are issued a year, I would say that a third.
There are 1,000 a year?
Yes, yeah. So those numbers are in the DV Fatality Review Commission report, actually. And so there are many more requested. I think there's like around 3,000 that are requested. Around 1,000 make it to that final phase where they could have this level of protection be ordered by a judge. So I would imagine that a third is a pretty high projection, where both a survivor requests and a judge orders it. And that number would, be a little less than twice as many people as we have in group right now, but our groups aren't full. So I think we could sustain that kind of an increase without any.
I'm not sure what number you're talking about. There's 400 to 500 now.
Yeah.
So with this bill, how many additional?
Well, I mean, I think we can
At a
only.
guesstimate.
Yeah, so my
I
guesstimate
mean,
would.
100, 200, 300, 400.
Yeah, I mean-
Just a simple answer like that.
So my guesstimate, which is a very heavy guesstimate on all of those factors, would be around 200,
Okay.
250. Yes.
Ian, then Ken, then Tom.
I just to clarify the testimony, the way I read it is that it doesn't really have to do with what the plaintiff requests, and that the court can order any of these conditions from A all the way through to I, proposed I, and that it's not, it's about what the court deems necessary to protect the plaintiff and the children. So I don't know if that's at least how I read this. So I don't know if that would change sort of how many would think there would be. I guess my experience has been like, oh, well, they could be programming straight. Let's order programming.
Yeah. Sorry.
No, I'm just, that's at least how, and I don't know, Michelle. Yeah.
Right.
Okay.
So my answer to that, you're absolutely correct. Legally, a judge can order what a judge can order, whether a plaintiff requests it or not. So I didn't mean to be inaccurate in that. My experience is that it is rare for judges to order protections that plaintiffs don't request. Also, you make a very good point about the fact that programming, you would think that well-meaning judges might want to order programming, which would be lovely in my opinion. But I still think that it is my experience that judges rarely order things that a plaintiff is not either requesting or on board with. It's just from my experience.
Are you good? Yeah. Ken, then Tom.
So to implement this bill, did I hear it was going to cost an additional 800 and some thousand?
No. 850,000 is what our current base funding that's in the state budget, and this would not be an increase in our funding. We wouldn't be seeking it.
So we wouldn't be going to, downstairs and going and requesting any more money, right? Okay, thank
Yeah,
you.
it's in the DOC's budget. Tom?
I can't remember what I was gonna ask.
So originally, folks end up there through a probative sentence or something. Could have been an incarcerated sentence as well? Yes? Okay. And then, so if if the judge issues an order here, which is a protective order, well, how much time is involved in the program? I
Heather,
guess.
do you want to speak to that?
Sure, I'm sorry.
Oh, no.
Yes.
At least adjust the placement of the chairs.
So most of the programs are 26 weeks long. We have 2 parenting programs that are shorter. So those are between 10 and 15 weeks long.
Hours wise, do you know?
Most groups are either an hour and a half a week, or we have more intensive groups that meet twice a week for 26 weeks. So there's a range of groups. But the majority of groups are meeting for an hour and a half a week.
I guess my own particular concern is, yes, it's a protective order and we need to keep people safe. And this is a great way to help someone stay safe. On the other side, I'm concerned with the fact that we're telling them that, well, mandating X number of hours that they have to do something is almost like a sentence to me. Without an option. So it seems to me that there would be some other, or maybe they can agree to under some type of other accommodation. I don't know. Hey, that sort of, you're telling somebody who hasn't been convicted of anything, oh, you've got to do this 26-week program. That's a pretty big deal for someone who hasn't been convicted. So that's just my concern.
Just legitimate.
But I also think it's a good idea. I'm just trying to feel this out. Okay.
Yeah, no, I agree. And we have some other questions that we're gonna get at that concern but Ken first, and then we'll get to a couple of these other ones.
So DOC agreed to fund this, for lack of better words?
Well, my answer would be that the Department of Corrections has a representative on the Domestic Violence Fatality Review Commission. And so all of the commissioners agreed to the recommendations that are in the report. And I mean, I can't disagree that the Department of Corrections is funding this, but what the Department of Corrections does is give that funding to the network to administer. We have a funding formula by which we fund all different programming that is certified by the Council on Domestic Violence, which the Department of Corrections also sits on the council. They also sit on our DV accountability program monitoring committee. So they've been present. Their representative has been present in all of the conversations about these recommendations and about the kinds of programming we offer. So that, I guess they've been part of the conversation all along, is my answer to that.
So thank you for that. They've been part of the conversation, but they haven't committed whether they're for this bill or not and whether they back it, correct?
Talk to them. I can't comment on whether the Department of Corrections supports this bill. Sorry.
So if they didn't, if DOC didn't agree with this bill and fund it, where's the money coming from?
I can speak to that. Yeah, I'll just speak to that and just say that Department of Corrections has been extremely supportive in establishing, for the record, Sarah Robinson from the Vermont Network. Department of Corrections has been very supportive in creating the space funding for these domestic violence accountability programs over the past several years. extremely supportive. And so, well, you know, certainly if the committee would like to ask the Department of Corrections their position on this bill, you absolutely should. Can't represent their position on this bill. I can say that they've been very supportive of this programming and of bringing more folks into this programming and having it more widely available to Vermonters.
So do you think they'd be as tight as their budget is, or however that works? Do you think that they would give out that allotment of money to support this?
Just to clarify, we're not asking for any additional money. This is money they're already expending. And regardless of whether this bill passes or not.
Okay, so I think we just went off. So in other words, they're going to give you X amount of dollars. You're going to decide where you're going to implement the dollars that best serve Vermonters, correct?
That is how.
And so right now.
How easy that was?
And right now, there are spaces available right now in these domestic violence accountability groups. And so, you know, we are excited to have more people who have a referral pathway to this very valuable programming. If they are coming from criminal court process or a civil court process, DCF, any other sources.
Thank you. Thank you, Sarah.
All right, so some of the questions that that we've posed to folks is, is really, what does completion mean, I guess, first of all, and who decides if somebody has completed a program?
So I can speak a little bit to that, and then if you want to fill in. So for most individuals, completion is actively participating in a required number of group sessions. And the DVAP, so like the program and program administrators, determine whether a defendant has successfully completed the program. And so with current referrals from the Department of Corrections, this is a process that already exists to evaluate if someone has successfully completed a DVAP, and it is a violation of their conditions of relief if they do not complete it. And so the process of kind of evaluating completion broadly is not a new process for DVAPs.
So there's really no definition of completion.
So you can speak kind of to the details, Heather, but the definition of completion is outlined a participation in a required number of DVAP sessions is kind of what is considered completion.
That means just showing up.
So, I don't know if you want to speak to kind of how DVAP providers kind of evaluate what is like active participation.
Yeah, so it's definitely not just showing up.
I think you said earlier that it was, the session is like 15 weeks or something like that.
26 weeks. Most programs are 26 weeks.
So we'll go from there.
Yeah, most programs are 26 weeks.
Okay.
So each program has a slightly different number of absences that they allow. But each program has a contract that lays that out very specifically. So when someone agrees to participate in a group, they read those guidelines. They're very clear. That's one of the standards that the council is it's what we're looking for when we look at everyone's program structure. And each program has slightly different, I would say, language about how they use like actively participate, but it's not just showing up. So it's like someone's interacting, someone's showing some progress, someone's engaging in conversation. So they need to be there for a certain number of groups.
So what would happen? So you got 26 weeks. Say I showed up 18 weeks and I was pretty good at participating for 18 weeks. But then you had somebody else who showed up all 26 weeks but was introverted. So they don't appear to be actively participating, but they're showing up every week. They could potentially be failed for showing up every week when somebody who shows up only 18 weeks could pass. Could that happen?
I don't believe that could happen because I think our programs have worked with people, these are really experienced group facilitators. So you have homework assignments, you have different kinds of discussion. I mean, these are curriculum that are built, quite honestly, for people who don't want to talk about what they're supposed to be there to talk about. So I think my confidence in the programs is that simply someone who's quiet or introverted would not be bailed out of the program because of those qualities of their participation. I think our program facilitators are adept at determining whether or not someone's engaging in the program.
Learning more about the program zone.
And we have a program facilitator from Rutland who is on the committee schedule for tomorrow, who can kind of speak to her very direct experience in navigating people's different personalities and learning styles in the program.
But to understand, you mentioned this is used in probation and condition of probation. And if they don't complete the program, they violated a condition of probation. So there is a process there to figure this out. Nevertheless, having said that, I'm still troubled that when you look at all the other issues, all the other orders or parts of the order that can be imposed, they're pretty black and white. You know if you've violated it or not. And I guess that's what we're hearing here is kind of the issue that if the program decides that they haven't successfully completed it, then this person's subject to a contempt order, violation of protective order, which is pretty serious, obviously. And presumably violation of probation also is fairly serious. So I think we really need to really understand and what completing this means, and maybe we need to, we'll hear from folks tomorrow, and maybe we hear from probation officers as well, or I mean, who else would look at this? I mean,
Can I speak to this just briefly? So I think it is a little bit apples and oranges in terms of someone who is completing domestic violence accountability as a condition of probation versus someone who might be ordered into domestic. There might be a condition of a relief from abuse order. The reason is that, and Judge Zone could speak to this, is that there is no compliance that a court does around any conditions of relief from abuse order. So when they say you need to stay away from the plaintiff, you need to vacate your residence, the court doesn't pull them back into court and ask, how's that going for you? There is no compliance process right now built into the family court process. So the only way that there's a violation of a relief from abuse order is if a complaint is made to law enforcement. So there has to be a criminal matter that is investigated as a violation of the order. So I'm not sure that there's an easy equivalence. I think it's a bit of apples and oranges in terms of how folks the consequences of not completing in whether you are doing that as a condition of probation versus a condition of a relief from abuse order.
Okay, but yeah, well, that's helpful. But the determination of completion, one could look to what happens with probation. In fact, the consequences seem to be higher there.
I think they are higher
than they are here. Okay, all right. Yeah, Ken.
So is this setup kind of like what you're going for is like what we're doing with diversion? Just a different. It sounds like it's kind of the same type of thing. Is there because there's accountability if you don't finish, right?
Oh. So, I mean, I think the process can be very different depending on if you're self-referring or you're referred by the Department of Corrections or by the Department of Children and Families. I mean, I think that, Vermont has been, a real kind of leader in thinking about how we look at accountability and changing behavior without an incarcerative sentence. And that kind of DVAPs are one component of that, which, I think it's notable that Justice Reinvestment in, 2020 kind of noted that, DVAPs are, a kind of key component of criminal justice reform programming. So I would say that there are some principles that are aligned there. I don't know, Heather, if you have anything to add.
Yeah, I mean, I think there are certainly principles aligned with diversion, but I would say that this program, and I'm not an expert in diversion by any stretch of the imagination, but what I imagine is the difference is that certainly right now, because most of the people who are participating in DV accountability program have a probably pretty serious sentence, as many of them may have been incarcerated for part of their sentence and then are being released into the community, and then on their conditions, then begin programming once they're released into the community. That is very a good percentage of the folks who are in this programming. So it is the emphasis on both understanding the harm that's caused and on developing skills to change the behavior is really probably similar to diversion, but I'm not intimately familiar with the content of the meetings that happen through diversion. So
Thank
I
you.
don't know if that answers your question or not. Feel free to ask me to try again.
I'm working out in my mind. It's complicated.
Okay.
Well, thank you.
Yeah.
Have you found, has the network found, and do you know of practitioners who would say that they may encounter multiple victims who of abuse who have been harmed by the same person?
Can I take that one?
Yeah, of course.
Yes. And so I am really glad you asked that, because the fatality review recommendation that started this whole conversation grew out of that exact situation. So it is really common for survivors when they find out that, because often they don't know going into a relationship, this person has been their partner has not only been abusive in other relationships, but has had a relief from abuse against them, to feel really frustrated with our system because there is not an avenue, for lack of a better way to say it, that kicks in to give people an opportunity to learn how to change their behavior before they end up being criminally charged. And so, so it frequently happens that someone who uses abusive behavior in one relationship and is not held accountable in any way. So there is no intervention other than that relationship ending for whatever reason, to go on and continue that behavior in their next relationship and their next relationship. And this recommendation, I mean, it grew out of the fatality review recommendation because we heard from survivors who not only learned that that someone had been abusive and had several relief from abuse orders against them, but that person went on to commit domestic violence homicide. So that is a very severe case. In years of working with survivors, through the legal clinic and through working at a network program, many survivors ask, is there something that, can be ordered for this person through the RFA process? Because obviously someone ends up applying for an RFA because they fear that they're in danger of bodily injury, but they also, in most cases, have children with the defendant. They're going to be in contact with the defendant for until that child reaches maturity. And they are not only wanting to be safe, but they don't want this to happen to somebody else. And they want the behavior to change. I mean, that's what survivors ask for over and over again. It's one of the reasons we wanted to get rid of participant fees. It's one of the reasons we've talked with, and we've already started working with DOC to get folks into programming earlier. There's a lot of, we talked about earlier, there's a lot of complications and concerns on the part of defense attorneys about getting people in earlier, but I think, I don't have a study to cite, but I think it stands to reason that the sooner someone's behavior is held accountable for the harm they caused and given some tools to change the behavior, the less likely it is they're going to cause harm in future relationships. And the less likely it is that they're going to cause worse harm.
Which makes the addition of this option in the RFA statute really potentially a proactive public safety choice.
I would absolutely say yes.
We can all acknowledge that domestic violence is one of the biggest public safety risks in Vermont, that, a very large percentage of crimes, violent crimes involving violence are related to domestic violence, which I would call a public safety issue. And the addition of this stipulation to the RFA statute is really about thinking about prevention in a more holistic way than what we have right now, which is is like the hope that if you're ordered to stay away from someone, that you'll stay away from them and magically stop hurting people. But we're not giving people any additional tools or education to change their own behavior. So it's relying on, a lot of things that have proven to be ineffective. So this seems to me like an attempt to be a little more effective in preventing future abuse, not just of the person who was already. We know that in order to get an RFA, you have to prove there was abuse and there's a risk of future abuse. So that's already checked those boxes. Now we're saying, let's try to help prevent future abuse of you and others. That's how I'm reading it. Is that accurate?
That's very well said.
Very well said. Yeah.
And in addition, I would just say that, in preparation for this testimony, we've spoken with people at the network and outside of the network who work with survivors throughout the RFA process. And it is something that survivors really want as part of the process that doesn't exist right now. Finding a path for changing behavior so that they can keep themselves safe, their children can be safe, future partners of their abusive partner can be safe. And I think creating a pathway to honor that desire is an important thing.
Okay, other questions? Yeah, Ian, go ahead.
I just, yes, we talked off camera and then I also raised it earlier. If just to give you guys an opportunity to respond to my concern around when you got a criminal charge pending and someone had requested an RFA is granted, if this were to be implemented. Give you guys thoughts.
Yeah, I would just say that, in her walkthrough, Michelle noted some potential language that could be added to specify that information, if there is a parallel criminal process, information disclosed in a DVAP cannot be brought into court. I think that is, language that we would feel comfortable with. Heather, I don't know if you want to talk at all about the potential for programming that is specific for people who are being referred in an RFA process.
Sure. Yeah. The other thought, because I've been thinking a lot about this too. So just to complete that thought, I mean, all of our programs already are having people sign a confidentiality agreement that has some things that aren't kept confidential. For instance, if someone walks into a group and threatens to kill their partner or their ex-partner, that's not going to be confidential. So there's already a structure in place for what's confidential in group and what's not, and every program has that. So I think there are modifications that can happen in those agreements there could be modifications in the statute that would make it perfectly clear. And then the third option, and protection would be that so as a result of the justice reinvestment recommendations, we have looked at our whole system of DV accountability programs and have added things like parenting programs. We're adding an LGBTQIA program. So being responsive to the landscape is what we're entirely focused on right now. And I think we could be responsive by thinking about, okay, what's the best curriculum for someone who's ordered to do this through an RFA? And maybe that's where we funnel all those folks. And again, I'm just, thinking out loud, but that would be extremely doable. And if I could add two things related to that, and right now, just in case folks don't know, so because of the pandemic, there's a lot of programming that happens virtually, which means that people aren't tied to their geographic area to do their programming. It also means that if I work on Tuesday nights, I could attend a group that happens virtually on Zoom on Wednesday mornings, early in the morning. Like the programs are all have different times. And so I wanted to let you know that. And then I guess the last thing I wanted to say is that just to build on, we want to do this for survivors to prevent further victimization, but also people who are abusive to their partners don't want to be. They want to change. They want to be different. They want to have good relationships with their kids. They want to have successful relationships with intimate partners. And so I think that it's also really helpful to think about the people who we would be ordering to do this. I mean, it's the desire is we give people skills to change things about their behavior that they want to change. That's my 2 cents.
Any other questions? All right, thank you very much. That's very helpful. And so we're going to take up more testimony on this tomorrow. And also we're going to have an amendment to H2 that takes 3 items, the first 3 sections, though slightly different from 223, to potentially put in here, just so we can have the various witnesses looking at all those items. So we'll